So Snyder versus Phelps is kind of a funny case in the First Amendment canon because it really came out of something that you might not think was related to the First Amendment at all, which is a tort case. The trouble for the Snyders when they tried to recover in tort against the Phelpses for damage is that the Supreme Court said that what the Phelpses did to damage the Snyders was all about speech, and not just speech, but political speech about matters of great public concern. But the fact is that the First Amendment has been applied as a defense in tort cases for a while now, way before Snyder versus Phelps. The First Amendment was first applied as a defense in a tort case in 1964 in the super famous case of New York Times versus Sullivan, which was a defamation case. But that was the first time that the Supreme Court stepped in and said this state tort law of defamation, which it had never thought raised a First Amendment issue. Actually, there is a First Amendment defense for this totally private state law cause of action. And the court said the way that the state of Alabama has constructed the elements of its torts presents too much of a danger of freedom to speech in the particular context that it came up in. Now, that was the New York Times, it was a media defendant. The speech was criticizing a public official in the exercise of the public official's duty. There were all sorts of reasons that sound very familiar to our flag-waving apple pie reasons, why we love the First Amendment, for that decision to have made sense as new and groundbreaking as it was in 1964. So the question is, isn't this case, Snyder versus Phelps in 2011, isn't this the same case? And my answer is no, it's not the same case at all. And the reason that they're not the same case goes back to the heart of what the First Amendment is all about. The First Amendment is all about the government not telling us that we have to espouse a certain view or that we're not allowed to put an idea into the marketplace of ideas. And the New York Times versus Sullivan reasoning, when the Supreme Court first found a First Amendment defense to the defamation tort, was all about popular sovereignty. And that's the real difference between New York Times versus Sullivan in this case. Justice Brennan's opinion in that case is founded on the notion of popular sovereignty, in that we as readers have a right to know what our government officials are up to. And the way that we're going to do that is by having the New York Times write about it. They're very different cases. So one is definitely about getting the public the information that it needs to know to make informed decisions at the ballot box. And the other one is about citizens determining, no, this kind of conduct that you're doing, picketing this way, at this time, in this place, that's not okay. That's actually outrageous. And we, the jury, think that that's a violation of the rights that we have against each other as citizens, which is very different than what was happening with the defamation verdict in Alabama.